Unlike social agreements, commercial agreements are legally binding. Then the question becomes, what are the legal issues relating to creation of such? Which is something we intend to look at here. In fact, the idea is to analyze the legal issues that relate to the creation of commercial agreements with customers or suppliers. The specific areas that we're going to focus on will include invitation to treat or invitation to negotiate, rules relating to offer and acceptance, consideration, intention to create legal relations, and capacity to contract, the battle of forms and precedence of contract terms, risks presented by contracting on suppliers' terms or through verbal contracts, the Vienna Convention on International Sale of Goods, as well as misrepresentations. Okay, look, so as you're going through this, I just want to point out that you can actually go to the website, zeritenetwork.com/courses. The link is in the description. And you can check out not only this video, you can check out other videos as well, other video lessons. And the interesting part is that as you're going through that, you also get to undertake some practice exercises, okay, based on what you've just learned. And at the end of the day, once you're done with the exercise, you can submit, check the details, see which questions you got right, see which questions you got wrong. And if you think, okay, let me redo this entire thing, just click, restart the course and take all that, and redo that again, okay? So the point is, you're trying to make the learning experience as comfortable and as realistic as possible. So you go through a lesson, you test yourself, so you can do that. Anyway, let's continue the video. Okay, so there are a number of reasons. In fact, there are many reasons, okay, why, whether you're a supplier or you're a buyer, you need to understand commercial law. In fact, you need to understand most of the things that relate to contract law. And some of these reasons include things like compliance with the law is mandatory. The law is dynamic and its requirements are always changing. Purchasing involves a number of activities which are the specific focus of the law and regulation, notably the development and performance of contracts with suppliers. Again, ignorance of the law is not defense, as well as the idea that a little knowledge is a dangerous thing. Now, having said that, okay, our focus in this case is going to be on commercial agreements, specifically contracts. What exactly is it that a contract do? You see, the idea behind a contract is actually to set out first of all, it is a legally binding agreement, right? And so the idea is to set out the obligations of the parties involved in that contract. If you're the buyer, what do you expect of you? If you're the seller, what do you expect of you? So you're talking about things like exactly what is it that the parties have agreed on. There is specifications, price, delivery and payment dates, conditions and contingencies which may alter the agreement. In short, circumstances under which it would be reasonable to enforce certain terms. Something like, if party A does X, then party B may do Y. Number 3, the rights of each party if the other fails to do what it has agreed to do. Basically, remedies should a contract be breached, okay? So things like those ones are set out in the contract. Another one, how responsibility or liability may be apportioned in the event of problems, for instance, who pays for damages or loss of goods. And finally, how any dispute will be resolved, for instance, arbitration. So the law of contract is about enforcing agreements or enforcing promises. But then again, it's not like if all promises are just going to be enforced because they are, because they are promises or because the parties agreed to them. In order for a promise to be legally enforceable as far as the law is concerned, it has to meet certain elements, okay? So you're talking about what really qualifies, what are the essentials of a valid contract or elements of a valid contract. So things like there must be a lawful offer followed by lawful acceptance. The intention to create legal relation must exist. That is pretty much the reason why if you promise to give your friend, whatever it is that you promise to give your friend, they're not necessarily going to sue you because of that. I mean, it's like somebody says, are we going to have coffee? And then you say, yep, I'm in. And then they don't show up. You're not going to sue them because the intention was not to create a legal relationship in that situation. Now, the next thing, there should be lawful consideration. By consideration, you're talking about the price paid by one party for the promise made by another. For instance, if you are watching this and you've paid, then there is that. There is the price that you've paid. That becomes your consideration. And then there is the idea that I'm taking, time and all this to make this. That is the price I'm willing to pay. So in every contract, there is always a price. You buy a car, you pay money. The person who's selling the car loses the car. So you lose money, the other guy loses the car. So that's the consideration, which has to be lawful. Something else, the parties must be competent to contract. The contract should be entered into voluntarily. There is, free consent. Something else, the parties must agree to a lawful object, which is just an interesting way of saying that the contract has to be legal. Of course, you can have an illegal contract. The problem is that you're talking about essentials of a valid contract, not essentials of a contract. All right. So for a contract to be valid, the subject matter or the object of that contract has to be legal. Finally, the contract must be capable of performance. So if some of the above, now if one thing or a few of those things that you've just mentioned is missing, then that can render the contract void or voidable. But the 5 main things that have to be there for a contract to actually exist are an offer. So somebody has to make an offer and someone has to accept that offer. So that will give them an agreement, or rather that will give an agreement. And then both of these parties, the offerer and the person who accepts the offer, have to provide a price, consideration. So there has to be a consideration and both parties must be of a capacity to contract, and then they must be willing that whatever it is that they are doing should create a legal relationship. When we talk about offers, we're talking about an expression of willingness to get into a contract on definite terms if those terms are accepted. I mean, that is the thing about an offer. And it is important for you to understand that. The person who makes an offer is called the offerer, while the party being addressed is the offeree. Now, an offer is interpreted according to an objective intention, not subjective. Meaning what? Meaning how a reasonable person in the position of the offeree would look upon the same statement or action of the offerer. It is important, okay? It is important for you to be in a position to answer the question, what exactly is an offer? In fact, look at this case. A firm of solicitors wrote to D on behalf of P and the board, inviting D to agree to a figure of £65,000 per year as the correct rental value. D accepted this proposal the following day. On 20th June, a partner in the firm of solicitor telephoned D to say that the letter of 22nd June contained an error and that P had intended to propose a rent of £126,000 per year. D refused to agree to this corrected proposal and claimed that there was a binding contract concluded by the 2 letters, that is, of the date 22nd and 23rd June. Well, looking at that, what do you think? I mean, yeah, so you tell me what you think. Because there is what the person is saying, look, the price you mentioned, okay, there was a mistake there. And then there's this guy who's saying, not really. I mean, you mentioned a price and accepted, and therefore we have a deal. In fact, you have a contract. So in this case, it was held that P was bound by the contract. This is because D would not reasonably have known of the mistake at the time of acceptance. Right. When it comes to offer, you also need to understand that an offer can be expressed, in which case somebody makes known whatever it is that they want. They tell you that. Or, they tell you in writing or through words. Or an offer can be implied, in which case it can be derived from the person's behavior or the person's conduct. It is important to realize from the beginning that not all communication will be offers. In fact, some could be statement of intention. Saying that you intend to do something does not really make it an offer. All right. In some cases, it could just be a request for information. I mean, look at something like this. Avi was interested in a piece of property owned by Fassi. He sent Fassi a telegram asking him the minimum price for which he would sell the property. Fassi quoted a price and Avi sent a telegram stating that he would pay it. So in this case, it was held that, now, if you look at that, okay, so in that case, it was held that a mere statement of the lowest price at which a vendor will sell is not an offer to sell at that price to the person making the inquiry. If that is confusing, what you're simply saying is that, think of it this way. Somebody asks you, you are selling something, okay, you're selling a t-shirt or something, and then they ask you, what is the lowest price you're willing to sell that t-shirt for? And then you say, well, I could sell it for 300. Then the person say, yeah, I'm going to buy it at that price. It's like, not really. You asked me what is the lowest price I'm willing to sell it for. You didn't ask me if that is what I'm going to sell it to you at. So those technicalities, okay, it's all about how you phrase it when it comes to things like contract. Something else that is also not an offer is invitation to treat. So invitation to treat is not an offer. An invitation to treat is an indication of willingness to conduct a business. In fact, what normally happens is that during the negotiation phase, most of the things we say sort of just fall under this category because we are just saying stuff. Why are we saying stuff? Because you're trying to invite the other person to get into a deal with us. So it's not really the case that whatever we are saying is mostly an offer. And also sometimes it can be, well, I mean, look at a case like this. So you have a Fisher v. Bell. So a shopkeeper displayed a flick knife in his window shop with a price tag behind it. He was charged with the offense of offering a flick knife for sale. The court had to determine whether the shopkeeper's act amounted to offering the knife for sale. Okay, so what do you think? Was the shopkeeper selling? And before you answer that, you just have to think of it this way. When you go to a supermarket, do they sell you things at the supermarket? Or do you offer to buy things in a supermarket? What do you really do? Because what you do is you pick something from the aisle and you take it to the counter and then you pay for it, which means they never really sold you the thing. They just displayed it with the price tag and then that's all they did. So in this case, that's pretty much what happened. The shopkeeper wasn't really selling in the strict sense of selling. In fact, it was held that it is clear that according to the ordinary law of contract, the display of an article with a price on it in a shop window is merely an invitation to treat. It is in no sense an offer for sale, the acceptance of which constitute a contract. The shopkeeper was therefore not liable. So at this point is an activity that I want you to think of, okay? Here's a question, here's a practical question. A local grocery places a leaflet through your letterbox. On the leaflet, it is printed, tomorrow only, oranges at a special low price of 50 shillings per kilo. Has the grocery shop made you an offer? If you visit the shop, must they sell you orange at this price? Think about that, and then we talk about something else, basically types of offers. Now, there are a number of ways in which you can classify offers. The first one is a counter-offer. Now, counter-offer is an offer whose effect is actually to extinguish a former offer. You're talking about something like this. A offered to sell a farm to B for £1,000. B replied offering to pay 960, which A refused. Sometimes later, B decided that he would pay the original 1,000. However, A declined the original offer, to which B sued for specific performance. Now, specific performance is actually it's an equitable remedy, in which case you are suing somebody to do what they intended to do in that contract. So like if you hire somebody to build a house and then they leave it halfway, you're not really suing them for money, you could be suing them because you want them to finish building the house. So in this case, the person was suing so that this other person can get into the contract at that particular price. It's pretty much the same thing you see with like the case of Elon Musk the case of Twitter and Elon Musk, okay? Where, Twitter is like, you need to buy this company at 44 billion or something. And then Elon is like, no, really, anyway, that's not the point. So back to this case. What do you think? Okay. It was held that B's action to pay 960 was a refusal followed by a counter offer which destroyed the original offer, and thus no contract came to existence. Here's what I'm saying. So you said, I'm selling at 1,000. And the person said, well, I'm willing to pay 700. So when they say they're going to pay 700, it means they've refused the 1,000, which means at this point, there is no offer, okay? When they say they're not going to pay 1,000, that 1,000 offer is gone. The current offer is 700. So you are offering to sell at 1,000. They've countered that by offering to buy at 700. So in this case, they've countered that by offering to buy at 960. And so when they go back and say, okay, I'll take the original 1,000, it's like, no, it doesn't exist. What you've actually done is you've just made a new offer of 1,000, which I can accept or I can refuse. And in this case, I've chosen to refuse. That is what happened in that case. So that is an example of a counter offer. Now, the other type of offer that we have is cross offer, which is the sort of offers that occur when both parties make each other offers unknowingly, and so the offers sort of cross each other. I write you an email offering to buy your phone. At the same time, you sent me an email saying that you're willing to sell your phone because somebody told you that I'm in the market looking for a phone. So you see, in this case, we've both made each other offer. So the effect is that we can't get into a contract because someone has to accept someone else's offer. All right. So one person has to be the offerer and the other person has to accept the other person's offer. That's pretty much how that works out at that stage. Now, number 3, another type of offer is conditional offer. Such offers are made subject to certain terms, which when accepted, the offer becomes valid. So think of something like buy one, get one free. What is the offer here? The offer is you'll get a free thing, but the condition is you must buy something else. So in fact, for the most part, this is just one of the safest way to ensure that you get what you want out of a contract by saying, okay, this will only happen if you do this first. So that is a conditional offer. And then you have single and standing offers, which you mostly meet in tenders. So somebody can say, I want 50 bags of, say, maize or something, or corn, depending on which country you are from. So if they say I want 50 bags of corn or 50 bags of maize, it's more of, okay, so when do you want them? And then they say you want them within a week. All right, so do you want them, all of them at once within a week, or do you want a certain number every day, but they must be 50 by the end of the week? So if they say it doesn't matter, you want 50 by the end of the week, then that is just a single offer. But then when they say you want 50 by the end of the week, but for the next, actually you want 50 for the next 5 days, which means every day you must supply 10. It should not be below 10, should not be above 10, then that is a standing offer. Again, look, if you have any question, don't just be like, yeah, ask the question, okay? Now, the thing about offers is that they must be communicated in order for them to be effective, because you can't just make an offer and then you fail to communicate it, because an offer only comes effective if it is accepted, right? And so in order for me to accept your offer, I must be aware of it. And so the communication has to be there. Something else that is important is that offers don't last forever, which means they have to be terminated. So the question is, how do we terminate offers? And there are a number of ways to do that, such as lapse of time, okay, the offer has expired, revocation, in which case you withdraw your offer, failure to meet a condition, in case of a conditional offer, then that's pretty much it. Counter offer, which as we already know, will extinguish the original offer. Rejection, you can reject an offer, and that's pretty much the thing with that offer. Death, but the interesting thing about death is that it depends on who's dead, because if a company, if say Google makes an offer, then that's just it. It's the company. So the person who made you that offer in Google is not really the person who made you the offer. It's the company that you're contracting with. So with death, the question becomes who's really dead. So if it is somebody whose personal services were expected in that contract and that person is dead, then obviously that offer dies with them. That's the thing with offers. All right. So let's move on to the next one. Now, for a contract to be formed, as you already know, is that the offer has to be accepted. And acceptance can take the form of express acceptance, where you actually say, yes, I've accepted, either in writing or whatever it is, by saying it, or implied, in which case the acceptance is going to be implied from your behavior. The thing about implied acceptance, however, is that there are two things which must exist. Number one, the party must show that they are aware of the offer. And number two, the party must also show that they are willing to accept that particular offer. Because if you're only aware of the offer, but you're not willing to accept it, then, that's pretty much it. And then again, you can't accept an offer that you're not aware of. I mean, that is the reason why, think of this example. Let's say you go to a supermarket and then you buy something, right? And then as you're walking out, somebody says, okay, so you've just bought this thing and they are giving you a free stuff in exchange for this. Where's your free one? And they're like, oh, really? And then you run back to the supermarket and be like, I just bought this and I want the free one. Now, must they give you the free thing? So if you're thinking yes, the answer is not really. They don't have to. In fact, if they do give you that, it's not because of a legal obligation. It is just customer care, okay? Because in order for them to give you that free thing, you must have been aware of the offer. That's number one. And number two, you must have been willing to accept it. Now, by paying, you are simply saying that you're actually saying two things. Either A, I'm aware of the offer and I don't want it, or two, I'm not really aware of the offer, and that is why I've paid and I've walked away. Okay? So by paying and walking away, that's what you're saying. So if you come back, then that's just another thing. That is the thing about acceptance, in which case we are using, behavior. All right? Look at this case. D offered to sell P certain items for 40 shillings cash, okay? Indicating that the offer would be open until the following Monday. P was a broker and would only buy once they had lined up a buyer to take from them. On Monday, P sent a telegram to D sounding out what flexibility there might be to negotiate before the day's trading got underway. Please wire whether you can accept 40 for delivery over 2 months. If not, longest time limit. There was no response from D, and P later purported to accept the original offer. D claimed that acceptance was not effective as their telegram had rejected the offer by way of counter offer. So you see, that's the thing, okay? If you ask information, asking for more information is not a counter offer. It's not even an acceptance, right? That's something you need to understand. So if somebody says, I'm selling this thing, and then you ask a question, that doesn't mean that you're accepting that thing. And that also doesn't mean that you're countering that thing. What it means is that you're only asking a question. In fact, you're seeking information. So in this case, it was held that the telegram was not a counter proposal, but a mere inquiry, which should have been answered. It was not as a rejection of the offer. Typically what happens in procurement, you're not going to be in a position, you mostly won't even be in a situation where like you're sending something and then, it won't really be that way. What will happen is that you'll realize that the other party is just countering your offer through standard forms. In fact, these is where battle of forms come in. So to understand that, just look at a case called Butler Machine Tool VXLO 1979. In which the offer to sell the machine on terms provided by Butler was destroyed by the counter-offer made by XLO. Therefore, the price variation clause was not part of the contract. The contract was concluded on XLO terms since Butler signed the acknowledged slip accepting those terms. So it is important to communicate your acceptance as well, because that is pretty much the way that we know that, you've accepted the contract, the offer, okay? Now, offer and acceptance are not enough for a contract to take place. In fact, what usually happens is that if you make an offer and the person accepts it, you simply have an agreement for the most part, okay? And then that agreement will be followed by a price, in this case consideration, and that's the deal, okay? Because somebody has to lose something. In fact, the whole thing is based on the principle of quid pro quo. Meaning what? Meaning something for something. Now, there are various types of consideration, talking about executory consideration, in which case nothing has happened, okay? Something has happened. You've promised to supply, they've promised to pay in the event that you supply. And then we have executed consideration, in which case either you've supplied or they've paid, or basically something has happened. In this case, the supplier supplied or the buyer has paid. So in that case, or even both parties, one has supplied and the other one has paid. So in that case, the consideration has been executed. Now, anything that happens after that becomes past consideration. And past consideration is not a good consideration. In fact, it's not even supposed to be part of that contract. It's one of those scenarios where somebody says, you've bought something and then you're walking away and then they tell you, don't worry, even if this thing goes bad, just bring it back. The problem is that they are saying that after you've already paid. So that is not even part of that deal, because if you bring it back and they fix it, so they're losing their time to fix it. What exactly are you losing? And if you say the price was part of everything that was said before you paid that price. And this is something that has been said after you've paid the price. So you see, that is past consideration, and it's not a good consideration. So the other thing that becomes part of creating a contract is the capacity contract, and this is one of those things that will just depend. It will vary from one country to another. In my country, for instance, anybody who is of the age of the majority can contract, and the age of the majority in this case is just 18 and above. So, it depends, okay? Although there are certain contracts that you enter into when you're 21. Take something like marriage, for instance. In my country, it's interesting because at 18, you can marry or be married, but then your parent has to be, or guardian has to be part of the deal. But if you're 21, it doesn't work that way. So that's generally how that works out. I don't know, how does it work out in your country? I mean, what is the age that somebody is considered an adult? You can let me know. That's not the problem here. The issue here is that is the general rule. But then there are exceptions. There are situations where minors can actually get into contract. And this is usually for contracts, number one, contracts for supply of necessary. In fact, by necessary, you're talking about something that the minor cannot do without, which is important because if it is proved that they could have done without, they could do without that thing, then that becomes a problem because now the contract becomes void. In fact, most contracts entered into by minors are just voidable at the option of the minor, which is the reason why it's not a good idea to get into serious contracts with minors. Look at this case. A tailor supplied an infant with 11 fancy waistcoats, but the infant failed to pay. Now, the infant was a university undergraduate. The father gave evidence that the infant was sufficiently provided for with proper clothes according to his station in life. It was held that the clothes were not necessary and the infant was not liable to pay for them. That's the thing. Now, another contract that minors can get into is beneficial contracts of service. For example, here we're talking about sports contract. I mean, you normally see these minors, athletes, and they get into contracts. This is a contract of service whose nature is such that, considered as a whole, it is intended for the minor's benefit. So an example here would be Doyle v. White City Stadium Limited, 1935. What if somebody is of unsound mind? The thing about persons of unsound minds and drunkards is that they are only liable in contracts when they're at that lucid stage where they know what they're doing. So the problem is actually you'll have to prove that they knew what they're doing. So usually the idea is just don't get into contact with somebody who's drunk. I mean, because then they can just use that as a vitiating factor. It's like, I wasn't aware of what I was doing. So that's the thing. The intention, okay? Intention is also important. In fact, it is very important when it comes to contract because the idea is that the parties must intend for legal consequences to follow. This is the reason why in some cases domestic agreements are not necessarily considered contracts. Well, they could be, but in most cases think of it this way. Let's say a husband and a wife. So the husband probably works in another city and the wife lives in another city, and then the husband says, I'll be sending X amount of money every week, okay, as part of whatever it is, house, whatever. And then the guy fails to send this money in a certain week. Now, can the wife sue? The question then becomes, when they were getting into that sort of agreement, did they intend for legal consequences to follow? So that is important, okay? So intention becomes a big deal when you're getting into a contract. And that is the reason why we tend to assume that commercial agreements, when parties get into commercial agreements, they intend for legal consequences to follow. So it's always important to remember that. Meaning what? Meaning at this point, now you know the 5 things that are important when it comes to creation of a contract. Offer, acceptance, consideration, capacity, okay, and intention to create a legal relationship. Of course, if there is any question, as obvious, do ask. At this point, it becomes obvious that, contracts can be, as you said, contracts can be expressed, contracts can be implied, meaning contract can be written, contract can be verbal. There are many types of contracts, okay? There is a danger, however, when you are dealing with verbal contracts. So what is the problem with verbal contracts? Here are some of the challenges that you might face. Number one, there is a risk that different parties to a discussion having different perception or recall of precisely what was agreed. Also, commitment to inappropriate terms, okay, that could happen. Mistakes in contract due to lack of genuine agreement, ambiguity of contractual terms, or even lack of terms to use in contract management. All those ones can be as a result of, verbal contracts. Now, we did mention earlier that sometimes you end up in a situation called battle of forms, okay? And you see, in order to understand that, just think of it this way. Companies, it's not just like you get into a deal and then you sign contracts. For the most part, companies can have their standard forms, okay? Or standard model forms or standard, they could have their standard terms. Think of it that way, right? And these terms are often written in documents that they use to do business. We're talking about things like RFQs, quotations submitted, order forms, delivery notes, goods received notes, and invoices. Now imagine if you order something, okay, and the delivery note has terms behind it, and then you sign that delivery note. So what exactly have you said? You've said that in addition to what I've just ordered, I've also accepted the terms that are part of the delivery note. What if some of the terms under the delivery note were that we are not going to maintain that thing? Especially, let's say you bought an electronic device and you are hoping that if there is a problem, the company can fix it for you. And you asked that while you're buying it. You're like, do you guys normally fix these things? And then the person was like, yeah, sure. But then the delivery note says that they're not going to fix that thing, but you didn't read it and you've just signed it. So in that case, while you made your offer, okay, the offer, or rather, while you stated your terms on the phone call, the terms that are going to be used are the last terms that you agreed to. In this case, whatever you signed in the delivery note. And that is actually the making of battle of form. The idea is that the last form wins, because usually that is the last one that you've accepted, and that is what you go with. That's the problem there. So to understand that, look at a practical procurement cycle. So the buyer sends a written inquiry to a potential supplier, okay, printed on a pre-printed form stating that any purchase made pursuant to the inquiry will be governed by the buyer's standard terms. So basically they're printed at the back of that form. The supplier responds by quoting details of price availability, stating that any sale will be governed by the supplier's own standard terms, which are also printed on the back of the form. The buyer just sent an inquiry, right? The supplier's response is an invitation to treat. They're like, if you're going to work with us, if you're going to buy anything from us, this is how that looks like. Make your move. The buyer may then place an order, okay? So the buyer makes an offer on standard form, repeating its own terms. Now the supplier may reply with an acknowledge of order, repeating its term, which means that they're countering the buyer's offer. So if the buyer goes ahead and accepts that, then you're dealing with the supplier's terms. Of course, there's a risk in that as well, but that is pretty much what happens in the procurement cycle. And that is, again, how the battle of forms takes place. So usually it's just a question of who sent the last form and was it accepted. A case that shows this was the case of Butler Machine Tool Company Limited, VXLO Corporation, 1979, which is something that we did briefly mention. So is actually what happened. Butler offered to sell using its own standard terms. XLO placed an order using its terms, which were different from Butler's. The order form had a tear-off slip, which the supplier had to return. Now that slip acknowledged the terms of the order. Butler did this. The courts held that the return of this slip was an acceptance of the terms and created the contract, which means now you are trading using those particular terms. And that is the reason why when it comes to battle of forms, the idea is always whoever, the last document wins, or that's pretty much is the last shot. The question then is, how do you prevent this if you're interested in preventing this? So if you're interested in preventing battle of forms, here are some of the things that you can pay attention to, or rather you can take into account. Number one, send acknowledgement copies of all inquiries accompanied by the buyer's terms, which the given supplier must complete and return. So that is number one thing that you can do. It's be like, look, this is what you want you to deal with, complete that, and then return it, and then you can have a business. And number two, send acknowledgement copies of all purchase orders which the supplier should sign and return, indicating agreement with the buyer's terms. If the seller acknowledges using its own documentation, for example by attaching terms and conditions, the buyer should write back stating that delivery will be on the buyer's condition. Number three, negotiate contract with suppliers, agreeing on specific terms and conditions which may include some of the buyer's standard terms and some of the seller's. So in this case, you see, that will probably take a lot of time, but at least you'll be getting into a contract that you've both agreed on, okay? And finally, check any revised terms or conditions, basically counter offers, which may be attached to the supplier's documentation. Stamp delivery notes with goods received on buyer's terms and conditions on receipt of goods. So by doing that, you'll actually be, avoiding battle of forms. So those are some of the ways that you can try and, avoid it. With the current trends in globalization, it's become so obvious that businesses are being done internationally, okay? When you buy something in whichever country it is that you're buying. So it's not like if you just have to buy something from your country, right? So then the problem becomes which country's rules do we use when you're contracting? And in case you have a problem, which court do we go to? So those are some of the issues that could arise. A buyer in an international trade can be faced with a lot of issues, such as when does offer or acceptance become effective in an international trade? When do title or property and risk in goods sold pass from the seller to the buyer? What are the rights of a party when goods do not conform to the contract? The United Nations Commission on International Trade Law, UNICITRAL, based on Vienna, has as one of its key objectives to further the progressive harmonization and unification of the law of international trade, which is pretty much the idea behind the Vienna Convention. The idea is, if you're going to do business internationally, then how do you make it such that it becomes frictionless? Okay. The uniform laws on sales define a sale of goods as international when the parties reside or operate in different nation states and goods are to be transported from one state to another, or where both offer and acceptance are made in one nation state and delivery is made in another. The Vienna Convention, however, is only applicable in certain specific situations. We're talking about things like it only applies to goods, that is, not services or works, but does include goods to be manufactured to specification of the buyer. Number two, it only applies to private commercial, business-to-business transaction, and not to public sector contract or sales to consumers. Number three, it only applies where the parties to the contract have their place of business in different contracting states. Now, the contracting states are the states that have actually accepted the Vienna Convention. So if your country is not part of that, then that doesn't really cover, which is something you can just Google and figure out if your country is part of the Vienna Conventions. At state level, countries signing up the treaty can exclude part of it. They can exclude some of its provision in respect of all goods. Alternatively, they can exclude the whole treaty from some part of their territory. For example, China is a signatory of the convention, but does not apply it to Hong Kong. Where the sale of goods is between two businesses in different contracting states, then it is international, and the contract of international sale of goods rules of law automatically apply unless they have been excluded. What happens if it is accepted? Okay, that is the question. What happens if those rules are accepted? Now, if the parties decide to go with the contract for international sale of goods, then they will accept certain obligations. We're talking about things like the seller has three fundamental duties. That is to deliver the goods, to deliver the relevant documentation, as well as to transfer property and goods. The buyer has two duties, which is to pay the price expressed in the contract of sales, as well as to take delivery according to the terms of the contract of sales. What type of goods fall under contracts of international sale of goods rules? The current interpretation of the contract for international sale of goods indicates that the following don't seem to actually, it sort of shows that it does not apply to the following sort of situations. Distribution agreements, since these are about the organization or transport on the goods and not the transfer of ownership. Goods bartered for other goods or service. There is anything where the payment is not money. Framework agreements, which are generally accepted not to be contracts. See, the framework agreements, you're just saying that this list of suppliers are part of the list that you've approved, part of the list of suppliers that you've approved. And then when you want something, we'll do a call off, okay? And then we'll get into a contract. So that is not really a contract. It's something else. Next, franchise agreements, the sale of ship or aircraft, the sale of electricity, all those ones are not really covered by the contracts for international sale of goods, as far as the current version is concerned. Right, now even with a contract in place, you can still have some factors that can, that can render that contract void. We're talking about the vitiating factors or vitiating elements. And these are things like mistake, misrepresentation, duress, undue influence, or even illegality. With misrepresentation, we're talking about, first of all, think of it this way. If you make a statement, okay, and that statement is designed to get the party into a contract, we call that one a representation. If that statement is false, it becomes a misrepresentation. In order for it to be a misrepresentation, number one, it must be a statement of fact. All right. Number two, it must be a misrepresentation of law, and it must be an active, number three, representation. So if you just say, in my opinion, I think this is going to happen, then that is not a statement of fact, that is an opinion. And if your opinion is faulty or if it's false, you cannot be sued on that basis, okay? Because you can't say, I acted in this contract based on an opinion. It would be like, not really. You need to act on a contract based on a fact. But then, if you're saying that, anyway, number four, the fourth thing that also will amount into a misrepresentation is it must be a material inducement. That is, it must be something that made you do something. Two things. Number one, does that mean that you must always say the truth in a contract? Well, the truth is, the law is not really concerned that much with whether you lie or you say the truth, because for starters, if you just say everybody must say the truth, you're going to have a problem in business. But there are situations where you really have to disclose. There are certain contracts where full disclosure is important. For example, insurance contracts. Basically, the contracts of utmost good faith, berima fidei. In those contracts, it is important for somebody to say the truth. So misrepresentation can render the contract void. The thing about misrepresentation, there are various types of misrepresentation. You're talking about fraudulent misrepresentation, where you actually just, lie, okay, because you're trying to commit a fraud. Negligent misrepresentation, where you misrepresent the truth without even caring about the effects of that. And then you also have innocent misrepresentation, where you actually say something believing it to be so, and yet it turns out not to be so. So that is a vitiating factor. Number two, mistake. So mistake simply is an error in belief, where you believe something to be so, and then it turns out not to be so. So mistake can also render a contract void or voidable depending on the type of mistakes. So here are the various types of mistakes that we have. Number one, common mistakes, which occurs when both parties assume one thing and yet the reality is different. Think about it this way. Let's say you are negotiating with somebody of tomatoes, and these tomatoes are in the care of someone else. And this person tries to, they are somewhere, they're far from you. And the tomatoes are about to go bad, and so this person tries to get hold of you, but they can't. So they effectively just sell the tomatoes because they're trying to save you some money. Meanwhile, you've just concluded the deal with the person you're negotiating with. So in this case, what has happened is that both of you have made a mistake. You are assuming the tomatoes are there, and therefore you are selling them. The person is assuming that you have them, and therefore they're buying. The truth is, they are no longer there. So that is a common mistake. And you see, the effect is that will render the contract void because it's not capable of performance, because the subject matter of the contract doesn't exist. Number two, mutual mistake, which is where both parties are under an error, but the error differs in the sense that neither is aware of the other's error. I mean, you're like, you have two cars and then I want to buy one. and the person thinks you want to buy their Mercedes, except according to you want to buy their BMW. And so when it comes to the actual execution of the contract, you realize, we didn't agree on the same thing. Now, this makes the contract voidable, because if the person says, no, I'm not selling my Mercedes, I'm actually selling my BMW, then like, okay, yeah, I'll take that one. And if they're like, no, I just want this one, then you see the contract can't occur. So the contract will happen, or rather will be executed, depending on the parties' behavior. That is a mutual mistake. Now we have a unilateral mistake, where one party makes a mistake, the other party is aware that you're making a mistake, and they don't. I mean, this is what usually happens when somebody is conning you. The problem with getting into a contract under unilateral mistake is that you have to prove that you got into that contract as a result of a mistake. Otherwise, the contract can actually bind you. Number 3, duress. With duress, you're talking about intentional violence or threats intended to get a party into an agreement. And the problem with this is that we said you need to get into a contract as a result of your own free consent. And so if somebody is forced into a contract, that usually makes the contract voidable at the option of the person who was forced into it. But for an action to amount to duress, okay, in order for you to sue, then it must be direct to the person and not to the goods. The threat should be based on something illegal. And finally, the threat or force must induce the party into a contract. And then we have undue influence. What exactly is that? We're talking about a contract is said to be induced by undue influence if one party uses their position to dominate the will of the other. This is a vitiating factor because it interferes with freedom of the other party to enter into a contract, again, willingly. Of course, there are situations where we just assume undue influence and it doesn't really affect the contract. We're talking about relationships like parent, child, doctor, client, solicitor, basically a lawyer and their client, okay, doctor and patient, not doctor, client, doctor, patient, a lawyer and the client. We sort of assume that. But undue influence, if proven, will render the contract voidable, yes. The stronger party can disapprove undue influence by showing that full disclosure of all material facts were made, the consideration was adequate, and the weaker party was in receipt of independent legal advice. And of course, finally, illegality. Now, that is kind of obvious. If whatever it is that you are getting into, the subject matter of that contract is illegal, then that will pretty much render the entire contract, well, void because it's illegal. So, vitiating factors: mistake, misrepresentation, duress, undue influence, and illegality. If there is any question, do ask. Now remember, the purpose of this class, the main objective of this class was to understand the legal issues that relate to the creation of commercial agreements with customers or suppliers. At this point, I hope you understand that. And by that, we also looked at specific areas. We're talking about invitation to treat or invitation to negotiate, rules relating to offer and acceptance, consideration, intention to create a legal relation, and capacity to contract. We also talked about battle of the forms and precedence of contract terms, risks presented by contracting on suppliers' terms or through verbal contracts, as well as the Vienna Convention on International Sale of Goods. We also talked about misrepresentation, that could render a contract. Basically the vitiating factors and all that. So if there is any question, do let me know. See you in the next video.